Hey Ryan, what can I do if I want to challenge an arbitration clause in a contract?
Well, the first thing you want to consider is if you even want to challenge the arbitration clause. A lot of people see arbitration clause and they say, I don't want to be a part of that. This is something that I want to stay in court with. But depending on the strength of the arbitration clause, one of the conversations you should have with your attorney is, should I even challenge this in the first place? Because what am I going to get out of it? Assuming that you and your attorney come to the conclusion that you do want to challenge the arbitration clause, there are a few different factors that you can use to argue against it. The first of which is that the arbitration clause was not actually a part of the contract that you signed. A lot of the times what will happen is you sign a contract and then there's terms and conditions which you never saw, which include an agreement to arbitrate, and there's an argument to be made that you are not a party to that contract. A second argument is that it was not conspicuous. Sometimes it's written in very fine print. It's something that you could have never noticed as a regular consumer or business owner, and therefore you can challenge it based on lack of conspicuousness as well as unconscionability. The last potential ground that I commonly see is a claim of fraud or misrepresentation of the contract. If you had discussed that there was no arbitration clause, if there's conflicting parts of the document which say arbitration is appropriate or trial before a judge and jury is appropriate, there's potentially an argument that the arbitration clause should not be enforced based on misrepresentation or fraud. If you're dealing with something like this, please call our office. We'd be happy to work through this with you.